members of getting the Healthcare Decision Act passed. He's always been very supportive of what our group is doing. So with that, Charles, I'm going to let you have it, and I do apologize for the group if they're staying a little bit longer than 2 o'clock.
Thank you, Judy. See if I can get the slideshow going. There we go. There's that part. Okay. And I will try to keep it to 30 minutes and leave a little time for questions even at the end. I'm going to talk a little bit about the 2013 revisions to the statute and then what that is going to reflect in the post form as the revisions are brought forward on that. And if time permits, I'd like to talk a little bit about needed updates in the advanced directive laws. As Judy mentioned, back in 2003, we put together a bill and brought that to the legislature that became the 2004 Healthcare Decisions Act. It was a fairly lengthy bill. Most of it dealt with advanced directives, but there was another section in there that talked about what we then called universal do not resuscitate orders. The UDNR in the statute adopted back in '04 only addressed withholding cardiopulmonary resuscitation. It only allowed for that universal do not resuscitate order, which we ultimately called the post, to be issued by a physician. It did not authorize, specifically said, it does not authorize withholding intravenous fluids, which we kind of overcame through rulemaking. And it did not address other life-sustaining treatment or palliative care. It defined a UDNR, this universal do not resuscitate order, as you see here, an order that was signed by the patient's physician stating that cardiopulmonary resuscitation should not be attempted. It could only be issued with the consent of the patient, or if the patient was not able to give consent and there was no agent, guardian, or other surrogate available, then on the decision of the physician, as before the statute, that, going to the discussion that was at the end of the last presentation, that it was not appropriate to offer cardiopulmonary resuscitation. In 2013, a bill was introduced in the legislature to rewrite that section to do two main things. One was to replace that cumbersome term, which sounded good when we were drafting the 2003 bill, but that had become difficult to work with and actually in practice been replaced by the more familiar term now, physician orders for scope of treatment post. But in the bill we'd called it the universal do not resuscitate order, because everybody knew then what a DNR order was, and we tried to amplify that by making it a universal do not resuscitate order, thinking that would be easier for people to understand, but pretty quickly moved on with the help of the pulse paradigm, the prevailing trends across the country, to this new phase that we called post. So we just simply went into the statute and searched and replaced UDNR with POST. So that's one fundamental change that probably reaches further than it would seem, but is the basic change between the original and the new statute. Then we also went in and where it allowed physicians to sign a post order, recognizing that there was need for other caregivers, particularly in the long-term care setting and in other settings where the physician might not be readily available, to be able to sign those forms and make them effective across different institutional settings. We added another section to permit physician assistants, nurse practitioners, and clinical nurse specialists to also sign off on a post form. Still, the form applies regardless of the institutional setting. So in the new bill, which now appears in the Tennessee Code, the post can do more things than just address, and must in fact do more things than just address cardiopulmonary resuscitation. Still, it may specify either or both of these things, except, as we'll see, where there's no patient or agent or guardian consent available. First, it should specify whether or not CPR should be attempted, whether it should be or should not be. So another little bit of a gloss on the prior statute. Secondly, then, other medical interventions that are to be provided or withheld. Just like the UDNR, a post may still be issued by a physician, but again, as with the prior bill, only with the consent of the patient or the patient surrogate, or again, if there's no surrogate consent available and the physician determines that CPR would be contrary to accepted medical standards. So still the statute focuses on CPR, and where there's no patient or surrogate involvement requires that determination to be made before a post is to be issued. The other section that we added to the new bill that was adopted this past year allows then the post to be issued by a PA, a nurse practitioner, or a certified clinical nurse, what is it, CNP? Clinical nurse specialist, isn't it?
It's probably a clinical nurse practitioner.
Practitioner.
Clinical nurse specialist.
I think it's CNP, I don't know, anyway.
CNS.
That's what I thought it was, I got in here CNP. All right, so this is where there's no physician present and available for discussion with the patient. So then what do? Well, the authority allows the post to be signed off on by the PA, nurse practitioner, or clinical nurse specialist if that authority is included in the protocols under which that extender operates, number one. And if the patient's either in a nursing home, an ICF MR facility, or in the process of being discharged or transferred from the hospital, then either with the informed consent of the patient, or again, as with the physician, if the patient's not able to participate and there's no surrogate to give consent, then the determination's made that CPR would be contrary to accepted medical standards, and again, the post can be issued.
Can I ask a question?
Please. Mm-hmm.
Just to clarify for these folks that are here, and maybe I need to go back and reread the law, but it was my understanding that the signing at the time of discharge was applied to all facility types, but in the way you're saying that, you're saying it's just for hospital discharge patients?
Nursing home, ICF MR, and hospital discharges.
Those three specialists that we talked about can only sign if they're at discharge, transfer or discharge, then they can sign it, but no other time can they sign it.
That's right. That's
Okay,
right.
that's right.
There's
I
a
just want to make sure everybody understands that you cannot have the nurse practitioner on admission to sign that post form.
There's a question or comment back there, I think. Is there?
What's the
Yeah.
question?
Yeah. Right. The question goes to if the patient's not in one of those named facilities, but in a residential hospice. And I think the answer is you have to have a physician. Go back to where it was. Right here, you have to have a physician then sign the form. There was much discussion, as you might imagine, as the bill was being developed, and a lot of change went into it with a lot of input from a lot of people, and there were restrictions placed over what the original bill would have said on what the extender can do. And that's where we got down to then naming the facilities and only on discharge or transfer. And I don't remember a discussion about residential hospice, but if it came up, it was not included, and so you go back then to having to have physician consent.
The reference to ICF-MR, which is Intermediate Care Facility / mental retardation, which is the old term, is that a reference to a singular state developmental center or community-based homes?
The statute's really very specific and refers to the part of the code that licenses those particular kind of facilities, and I can't tell you all the nuances about which ones are included in that. Yeah. Okay. So I brought paper, of course. I've got a handout that's going to go around right now that deals more with the advanced directives in Tennessee. Before we go there, I didn't bring you a copy of the new draft of the post form, but there will be a new draft proposed to the licensing boards and discussed that will reflect then these changes in the statute, getting away from the old UDNR term and accommodating signature by an extender. And there'll be more on that later. Mike.
One point of clarification, we actually went to the licensure board after the law was passed this year, recognizing that it takes a long time for the licensure, the process basically to change the form in the state. So we asked that we go ahead and use the existing form with the new law, and they allowed that to happen. So the existing post form, although it says physician signature on there, because the law's been changed, you can have those other extenders
Sure.
sign the form because the law's been changed.
It's an important point. Just be sure everybody heard that. The old forms can, the old forms can be used because the statute's effective now by nurse practitioners, PAs, and CNSs moving forward.
The original law said that it had to be signed by the patient's physician. The 2013 revision says by a physician.
Yes.
Is there a distinction between by the patient's physician and by a physician?
Yeah, I'm going to reach down here and grab the statute and read with you. I've got that already. Well, it goes a little further. You're right, the language is different, but what it actually says, you read it, the whole phrase there, may be issued by a physician for a patient with whom the physician has a bona fide physician-patient relationship. So really getting at the same thing. It was a definitional issue, more so than a change in meaning. Okay, before the Healthcare Decisions Act, again 2003, effective in 2004, we had living wills and durable powers of attorney for health care in Tennessee. I was thinking during the prior presentation about how those came about, and primarily after several of those 1970s, 1980s Supreme Court decisions had made so much news, this whole idea about living wills came forward, and really wasn't the caregivers asking for it, right? It was people out in the community who were afraid of being kept alive on machines or tubes or however it was commonly viewed at the time, clamored for that kind of legislation, and so we had our living will statute adopted. Followed in the next year, I think it was 1991, by a durable power of attorney for health care statute. I could bore you probably for quite a while with all the historical development of those laws, but we had those in place back when the Healthcare Decisions Act was being developed, and the original idea would have been to repeal those old antiquated laws and replace them with better new forms, but there was resistance to that because by that point we found that the idea of living wills and the use of the forms had developed a following, and there was some comfort with those forms. So the Healthcare Decisions Act did not repeal those, but allowed those to continue. Interestingly, in 2007, a bill was introduced and passed in the legislature that made the old forms, made the old statutes anyway, more like the new statutes in that the attestation requirements that had been more cumbersome in the old laws were made a little bit more like the Healthcare Decisions Act, such that you don't have drastic differences between the two, except that now you have different forms. What I've just handed out is kind of a wild idea of mine. It hasn't been vetted elsewhere, so this is not something that any group is promoting, at least not yet, in the legislature, but is an idea of how we might simplify advance directives in our state law. And the idea, if you flip to, let's see, if you flip to page 3 of the handout, is to change our existing advanced care plan form. The form that you see there is mostly as it is now promulgated by the Board for Licensing Healthcare Facilities, Department of Health. It does one little thing significantly between that current form and what would then be the new statutory form. Under the caption Advanced Care Plan, it puts the title Living Will in parentheses. So whether you use the old form or the new form, they say they work very differently, but it's still, both are consistent with both the statute both the Living Will Statute and the Healthcare Decisions Act, and consistent with the popular notion of what a living will is. You know, one of the criticisms of that term living will all along has been that, well, it's not a will, and it's not about living. So, you know, why do you even call it that? What the heck is it? And people have this sort of vague notion about what a living will is. The idea here would be to eliminate that old form, which is complicated, not useful in the clinical setting, and replace it with something that is useful, and at the same time take what we're now dealing with, 3 forms or more. It was mentioned earlier in one of the presentations, we have a separate form that we use or can be used for simply appointing an agent, or you can have a uniform durable power of attorney for health care with all kinds of strange terminology and a big warning statement that takes up half a page. That's the same thing as an appointment of agent. Or you can have an advanced care plan, which also appoints an agent. And so you get the question, do I need to have 1, 2, 3? What do I need, and what the heck is it, and what's an advanced care plan? Well, I think just by simply calling it a living will, it'll explain to a lot of people what it does. People kind of generally understand what a living will is intended to do, at least. And it gives you everything right there in one place. As I vetted this with a few estate planners, they unexpectedly liked the idea of having it all in one form. And among other things, they said, if you have this new form and it provides right at the top of the first page a mechanism for appointing an agent, and the client says, no, I don't want to appoint an agent, they just exit out, it shows that you offered that and they chose not to have it. Or if you give this to somebody and they're ready to appoint an agent but not ready to think about all those difficult decisions, and they X out the bottom of the first page, you've shown you've given them that opportunity as well. So far it's gotten good reviews from the lawyers who counsel clients on such things in a typical setting. The old living will law has a segment in it that you see reflected on this slide that has a lot of troublesome verbiage in it. So the first thing that the bill would do would be to go back and amend that old living will law to clean that up a little bit. And so what you see in the handout would be the language that would be proposed. This slide breaks it down and shows you the language that it replaces. So where the current living will law says that medical care includes various things, then this part shall not be interpreted to allow the withholding or withdrawal of simple nourishment or fluids. Well, what's simple? You just don't need that word. So as to condone death by starvation or dehydration. You know, just scary stuff that was put in there, again, back in an era when we were thinking very differently about this. And then I just simplified the rest of the language. Unless the instrument that creates the living will or durable power of attorney for health care includes a specific declaration of that intent, which the post form would, of course, and which the advanced care plan would. So that's just a simplification and didn't take much. That's the really one of 2 modifications proposed here in the living will law that simplifies that definition. And then the second thing that the bill would do would be to simply take out that old form, again, that's not very helpful, not very informative in the clinical setting, that has all kinds of scary stuff in it that's hard to understand. Just get rid of that form and replace it in the statute with the advanced care plan, which you've got in your handout. After we adopted the Healthcare Decisions Act, after that passed through the legislature, signed by the governor, we then expected the rulemaking process to move right along and get these things done, and it didn't happen that way. It took a very long time. There was a huge amount of confusion. More recently, we've gotten all that straightened out, but to avoid a repetition of that and to provide more predictability, this bill would propose to adopt a form actually by statute, with the idea that you could still use other forms. And so the bill reflects that you could still use forms that are approved by the Board for licensing healthcare facilities. You could still use any form that complies with the Healthcare Decisions Act. And many lawyers will use an extended license with that and will draft their own forms. Institutions across the state now, some are using the 5 wishes form, or other forms that also comply with the statute. Another thing that the bill would do there at the bottom of the first page of the bill would be to get rid of that wordy half-page warning statement to say you don't have to have that any longer for a durable power of attorney for health care if you simply use the statutory form or some other form that meets the requirements for appointing an agent under the Health Care Decisions Act. So then you'd get down from these 3 complicated forms, all these choices and various decisions to be made, down to this one form that then we could focus on and hopefully minimize confusion about which form to use and what to do. You still would preserve the validity of living wills, durable powers of attorney for health care, or other instruments adopted under the old laws. One of the good things that I think has been brought out today that I hope we'll have more dialogue about, Judy, in the future, is the notion of informed decisions using any of these advanced directive mechanisms. We have a long way to go to achieve that, and I'll look forward to further discussion about that. So with that, are there questions or other comments?